Everyone, we look nice and warm. It shows that we are going to have a very lively debate this evening. Without taking much of your time, let me call upon Mr. Sibusiso Pule, who is the chairman of Northern Rose Fulbright, our hosts in this part of South Africa, Johannesburg, Sandton to be specific. It's said to be the most expensive square mile on the continent. So we are standing on very, very serious ground. Mr. Sibusiso Pule, representing the Northern Rose Fulbright, let me pass it on to you.
The South African branch of the firm. We are an international law firm that has about 3,800 attorneys around the world in over 50 cities around the world. We represent various corporate clients, including governments and state-owned entities in all the continents of the world. But we are not here about that. And one of the things that I would like to talk about, which is very important and which is very close to our hearts, and hence the association of the firm with the J.L. Dube Foundation, is that as a firm, we just don't believe in doing billing work only. We believe that as a firm, as an organization, we do owe it to the communities in which we operate to give back. In other words, to make a difference in the lives of the people in the communities that we live in. There are quite a number of land claims that the firm has been associated with, where we have done those claims free of charge as a service to the communities that we live in. One of them that come to mind is the land claim that we did on behalf of a community out in the Wild Coast, where a certain casino operated by a certain company, which shall remain nameless for professional reasons, was situated. These people for a long time, they were not getting market-related lease money in respect of the land where this casino is situated. That land claim had been dealt with by another firm of attorneys, and it was not going well. As a result, we were requested to intervene. Patrick Brasher here, who's sitting in the audience, one of our senior partners, was approached and he took over the matter and he breathed life into the matter. And we were happy that we ended up not in court, because the other side got cold feet. As a result, the matter was settled and the community was given quite a huge sum of money. And as we speak today, they are getting fair rental in respect of that land. So those are the kind of things that we do as a firm, because we deeply believe and subscribe to the philosophy of Ubuntu. Hence our association with the J.L. Dube Foundation. Now, I am also reminded in terms of this important topic that is going to be discussed here tonight of the words of our Chief Justice, the Honorable Justice Mogoeng, on the occasion of the 40th celebration of the formation of the BMF, I think it was during the last month, where he was saying and alluding to the fact that the land issue is a complex and a perplexed issue, and an issue, because people are going to think that I'm talking politics, I am talking about something that is enshrined in the Constitution, which is one of the rights that our people should be having access to. So with those few words, I welcome you to our humble place of work, and I wish you a very lively and enriching debate. I certainly hope that I will learn, and there is some good takeaway that I and hopefully you are going to take from this debate. With those words, thank you very much. I don't know whether I should be handing now over to Professor Nzimande or I should be handing back to you, MC.
I think you have done part of my job. And you call it a humble place. This one is such a beautiful place. And I'll tell you that the homeless would not want to go out once they will be accommodated here temporarily, because it's more of a nice environment that we find ourselves in, and we're looking at the descriptive environment that defines where we are today. Let me greet you all, ladies and gentlemen, and on that note, try my best to outline what we stand for as an institute. My name is Sipho Nzimande, and I'm Deputy Chair for the J.L. Dube Institute. This institute is an institute of the University of KwaZulu-Natal, and we're honored and privileged to host you today. And the institute really and truly, it is humbled. One thing we were certain about was that we needed to succeed by all means in the path we have embarked on. That is, it is not the first time that we have such an event. It is the second time, and each time we do it, we get used to the habit, we get to internalize it so well. In other words, we get to know what we're doing. The Institute was formed with the intentions of carrying forward the ideals, the values, and aspirations of the legendary statesman, Dr. John Lebalele Dube, Umafukuzela. The Institute was established after receiving the full blessings of the Dube family. Our mission, therefore, is to provide high standard research and expand the horizons of knowledge through education and research, and to inspire, encourage, and promote humanitarian activities with a view to prevent and alleviate human suffering and poverty. In striving to achieve the above, the Institute provides a space for local and international organizations from all sectors to engage in policy debates and influence policy implementation. The Institute also engages in socio-economic research on development-related issues aimed at addressing challenges in the country. It is also serving as a link between government, industry, and the community. It is within this mandate that the Institute has initiated this roundtable discussion on land distribution in South Africa and the legislation governing it thereof. The Institute, having dealt with a number of claims that were dismissed by the Commission on restitution of land rights based solely on the fact that the dispossessions happened before 1913, felt it was within its mandate to submit a proposal for the review of Section 25, Section 7 of the Constitution. Section 25 therefore goes, a person or community dispossessed of property after 19 June 1913 as a result of past racially discriminatory laws or practices is entitled to the extent provided by an act of parliament, either to restitution of that property or to equitable redress. The Institute's contention against the use of the 19th of June 1913 as the cut-off date is based on a number of questions, and these include, amongst others, why was this date chosen and accepted as the cut-off date? Does the history of the first interactions between the different races of this country support the notion that land dispossession only began after the passing of the Native Land Act of 1913? Does the inclusion of this date not infringe on the constitutional rights of those who lost their rights in land due to racial practices before 1913? Why the issue of the land disposition fell outside the scope of the Truth and Reconciliation Committee, if its mandate was to deal with the gross violation of human rights? The Sunset Clause, a breakthrough proposal which led to the government of national unity, will all remember that, as it gave the concessions to the National Party. But when will it be a sunrise clause? The intention of the institution is that this section of the Constitution should be reviewed urgently, and the date removed altogether, or a date reflecting the true historical events of how the majority of Africans lost their land as a result of the unscrupulous settlers who were hell-bent on getting their hands on the most fertile regions of this country. It is a common cause that the greatest accelerated land disposition occurred during the 19th century, starting from 1803. The 19th century was a period of several events whose social, political, and economic impact profoundly changed South Africa and the African continent. Colonial conquest, and state that this colonial conquest was to result in the process that led to the formation of the Union of South Africa, a process that included an economic deal between the Boers and the British that is still largely in operation till today. The economic suffering of black people, who are a majority, can be traced back to the events of land dispossession, and it should not take a rocket scientist to understand that equitable sharing of land resources will go a long way in ensuring economic empowerment of the black majority. The Institute is therefore calling upon all of you, politicians, participants, and those stakeholders who have a voice in the community, to do their best in participating towards this mobilization that we have started. As you can be able to do this by firstly ensuring that the submission of the Institute is in the debate, or for the debate, is voted for in a 3/3 majority format. The Institute will do everything in its powers to keep this matter in the minds of the public. We have not ended with this attempt of today. So that if everything fails, we will do all what we can and be vigorous in doing that. So that in the end, if a possibility of a referendum becomes possible as an outcome of this attempt, it will be so. Ladies and gentlemen, let me welcome you to this debate and hand over to Dr. Mtene to start to moderate and engage with the participants. Let's enjoy the fruits and enjoy the rich content from these brains, who are very, very passionate.
Thank you very much, Prof. Nzimande. In fact, I stand before you today on borrowed ropes out of the interest of and in trying to gauge the temperature of society in relation to this very topical matter that some have called the elephant in the room, some have called the Achilles heel of South Africa. My story, as the story of all black people in South Africa, I believe every one of us has got a story in relation to land disposition. My name is Zaitz Kagisomotene. I come from Bafokeng in the northwest. My community lived in the Rustenburg Valley. We are dated right up to the 1200s. We, over time, hosted various black communities. Came the 1800s during the wars of Ifekani, when nations were scattered all over, when other nations joined us, assimilated to even become bigger. We even had the great Mzilikazi on his track from Natal through Carindale, Limpopo, Dimole, Wombats, coming to even settle amongst us. He was driven out in 1837 by the front column of the Voortrekkers under Henry Potgieter. We then, in the 1850s, in the 1840s, had the next column of Boers. I think we must be correct, because between the 1800s and the 1900s, in fact, until the formation of the Broederbond in the 1920s, there was no nation called Afrikaners. The people that left the Cape Colony were called Voortrekkers, and then they referred to themselves as Boers, trekkers, or beggars. Beggars which meant citizens. So in that group that descended onto the Rustenburg Valley, there was one significant Boer who rose among the ranks of the Boer community to even become the leader of the Zuid-Afrikaanse Republic that was declared unilaterally so in 1856. This man was Paul Kruger. Now, the interesting story, as you would all know, there's a farm that he occupied in the Rustenburg Valley that is called Buchenhoutfontein. That farm is my ancestral land. We have graves of my ancestors there, and we have to get to some form of understanding as South Africans in this day, in 2016, to resolve this matter once and for all. We are all victims of circumstances, as I like to say. We should not spare any ounce of energy to eventually resolve this matter once and for all, for the benefit of all of us, for the benefit of our children and generations to come. Now, with that little intro, I think one would have picked on two things as the speakers were outlining. But I wish to beg your indulgence to request that we hold just a minute of silence for prayer, meditation, in remembrance of our heroes. And thank you very much. A think tank of the intellectual gymnastics that we are bound to have this evening. I hope we will debate with vigor. Prof. Nzimande already said there was a sunset clause. When are we going to see the sunrise? We have been very fortunate that with all that happened, from the 1500s to this very day, records were kept, very beautiful records. Are we still going to live by the adage that to hide anything from a person of color, put it in a book? We have all these records. We have history to learn and know what our next steps should be. So without much ado, let me introduce our panelists. I will start with Dr. Maureen Tong. Dr. Tong comes from the Thabo Mbeki Library, which is based at the University of South Africa. Next to her is Dr. Mulungisi Ngobo, one of our very brilliant researchers at the John Langalibalele Dube Institute. I mean, a young man like him has sacrificed everything to really understand these matters and be a researcher at this institute.
The institute had invited me to come and be here and to speak here. I was actually looking forward to the participation of Dr. Mayende because he was my boss for many years. When he was Director General, I was the CEO in the department. And those were the years at which really the policy developments, if you like, for the Land Claims Commission were being developed. So I guess you'd say I was there at the much earlier stages. My training is in law, and therefore I would really deal with the issue mainly from a legal point of view. I must say I congratulate the Institute for the research that's been done. It's quite impressive, the amount of information that's contained on the timeline that's included here. I took a bit of time to walk around the room to read the posters that I put up. And for me, that's really a great thing to be done because a lot of times in South Africa, we do not have a clear sense as a country of the extent to which the land disposition runs. Indeed, and I want to also congratulate the Institute for raising the question. As a lawyer, the question is the date of 19 June 1913 constitutional? I'll say yes. As a matter of law, it is constitutional. Why do I say this? Because, and maybe I don't know how much time I have, Chair, to take a bit of history and talk about how we ended up with 19 June 1913. My point now is that it is constitutional, but it's an issue. The reason we do need to change it, I fully support the research that's done by the Institute, and the points that I raised are very true. That the land dispossession really is at the center of many of the problems that we have in South Africa. And the land question remains unresolved, and as the chair of the law firm has indicated, and I concur with what the former Chief Justice says, that unless we resolve the land question in South Africa speedily, we're heading for very difficult times ahead. 19 June 1913 became a decision and became part of the Bill of Rights in South Africa, following what had happened previously. We had in the interim constitution section 23, which was the property rights clause. Before we had the final constitution, we had the interim constitution. Section 23 of the interim constitution was what we call a classic property clause. In other words, it was a constitutional clause that says that the right to property is constitutionally protected. There had been a lot of discomfort about what that meant for the democratic dispensation in South Africa. As the history shows in the information that's put up on the wall, the land question really runs to the core of South Africa going back to those many years. And certainly the current inequality that we have, the dispossession, the landlessness that we have currently have their roots in the way in which the land question was dealt with. It's an issue of colonialism very clearly, and this is the result that we have. So what happened was when the country was discussing during the interim constitution, making a decision of what would be then in the final constitution, there had been a lot of anxiety about if you protect property rights, then you're going to make it very, very difficult for the new government, the post-apartheid government, to be able to deal with land reform. And in fact, the property rights clause was one of the very, very last clauses to be agreed upon during the discussions. And the reason why Section 25 is crafted the way that it is has its roots in that history. The discomfort at the time was, and there were several case studies that we looked at the time, was that if you look at, for example, in India and Canada, they had property clauses, but what happened was there was a situation where a lot of times Parliament would pass, rather the court would say, you know, the property clause of the Constitution is unconstitutional because the property clause went against the values or rather the rights of property that are contained in the Constitution. The anxiety therefore was that you do not want South Africa, the post-apartheid South Africa, to be burdened with that problem where the courts would then say that the property right clause is unconstitutional, or most importantly actually, that we could not do land reform. That then a compromise, if you like, that was reached is that finally then, in the final constitution, would have a clause like Section 25. Section 25 was put in the Bill of Rights. For those that study the law or constitutional law for that matter, would know that that any rights that's included in the Bill of Rights is separate from other rights that are contained in the Constitution for the simple reason. In order for you to be able to amend anything in the Bill of Rights, you need 2/3 majority of Parliament sitting together to agree to change that clause. So such was the anxiety that any future decision that you made around property and land reform in South Africa would not be a matter of just passing an act of Parliament. You cannot tomorrow just pass an act of Parliament and say that we no longer like 19 June 1913. To be able to do that, you actually have to constitute 2/3 of Parliament should be sitting together and agreeing to that in order to change any clause that's in the Bill of Rights. That's the reality of what we have, and therefore with Section 25. But not only that, to say also, if it's one of the most elaborate, if you look at all the rights that are contained in the Bill of Rights, Section 25 is one of the most elaborate one. Not only was there a decision to say you don't make any changes to the to rights to property without actually amending the Constitution itself, and I think that's why the question is posed in that way, to say is it unconstitutional? In order to change 19 June 1913, you have to change the Constitution itself. Unlike the extension that was done recently to extend the cut-off point of lodging new claims, you could do that by way of an act of Parliament. But for 19 June, you have to change the Constitution itself. But not only that, they went further to say, if you're going to do land reform, Section 25 itself must detail as far as possible, basically the extent to which you can do land reform. The very content of the entire restitution program in South Africa, you will find in Section 25. 10-year reform legislation, any form of legislation that South Africa can pass, will have to find its own roots in Section 25 of the Constitution. So it's tenure and restitution, and even redistribution. And hence, at least during the time when I was in government, we used to talk of the three.
Position of leading, or as one of the people who lead this nation, I feel that those compromises are not valid right now, and we need to make the changes that will address issues that are facing our nation right now, and one of those changes is the dates of 1913, 19 June 1913. I will just read one of the preamble of the Constitution. It talks about healing the divisions of the past and establishing a society based on democratic values, social justice, and fundamental human rights. The truth of the matter is that 22 years down the line, we have not achieved that. So we really need to make changes. That is going to be my opening remark, and a lot of what I will talk about will be based on what I believe will be the valid changes that we need to make starting from today. Or if it was in my powers, I would make the changes today, not tomorrow. Even the elections to me are not that important. This is the vote that needs to happen tomorrow, if it was possible in my powers. Thank you.
Thank you very much, Michelle. I think it was Frans Fanon, who I will paraphrase, who said, every